prosecutors who are appearing here, notably Mr. Wood and Ms. Blake are appearing, and I understand Ms. Blake will be representing the state in any argument today. Council, I called this status conference also at the request of the parties just to touch on some issues as we approach our trial setting, which will be coming up early next year. There's a few issues I wanted to discuss. The first issue involves the trial and the length. We're looking at, based on the experience we had in the companion case, timing to get questionnaires done and completed and reviewed as we conduct that portion of the trial for voir dire before evidence. We're scheduled to start evidence on April 1st, and the court would consider that we probably want at least the full week before, like we had in the first case, if not some additional days. So I'd like to get some input on when the parties think we should potentially commence the passing out of questionnaires to potential jurors, who will then submit those, and then we'll, of course, take those back for review before we start the actual voir dire. Looking at the calendar, I was considering either 2 weeks or a week and a half. We did it in a week before, and I think this questionnaire, where it's a capital case, may take longer to both review and to fill out. So we may need to have some smaller groups. So I'm looking at maybe starting that process the week of the 18th of March, possibly on the 18th or the 20th. I don't know that we would have really enough time if we took just 1 week starting on the 25th. So that's kind of the first topic I want to discuss, and I just want to get council's input on that. Ms. Blake, starting with the state, what do you think about the necessary time we'll need to go through questionnaires, get those submitted, and review them before we can start our group voir dire?
Your Honor, I think the state is in agreement with what's been represented by the court. We would be inclined to recommend that we set a 2-week time period for that. Just essentially better safe than sorry if we get through them a little bit quicker. Otherwise, I think that it may delay the start of trial if we didn't have them selected. So I guess whether we want to be a little flexible on the actual day that we start the trial, or whether we want to come in a little earlier before the set start date, would be in the court's discretion, obviously. But I think if we do 2 weeks, that would be sufficient to make sure we had plenty of time.
Okay, well, I appreciate your comments. And of course, part of that decision affects when we get things set up and are going to be there, and need to coordinate that with Ada County. And I've confirmed that they are available in those timeframes to begin if that's when we choose to start. Mr. Pryor, on behalf of the defense, what are your thoughts on starting with the distribution of questionnaires to a jury pool?
Judge, I agree with the court's analysis, and that 2 weeks is appropriate.
Okay. I will confirm those dates and get back to council. We'll still have a starting proposed date for evidence of April 1st, but we'll look at questionnaire process likely on the 18th of March. So we may submit a supplemental order that covers that. If not, I'll just make sure that council's advised of the dates we'll be doing that. So that's the first issue I wanted to discuss. In terms of our length of trial, assuming we do start evidence on or about the 1st of April, we've got it set through the months of April and May as it currently sits. I just wanted to get an update from the state as to whether or not you think that is still a accurate time frame for your trial, Ms. Blake.
Your Honor, I think the 8 weeks would be sufficient for the state's anticipation of the length of this trial. I think, again, given some of the differences with this one versus the companion case, including that it is still a death penalty case, I think having that longer period of time for the trial is appropriate and would give us enough coverage if we set it for the 8 weeks, not including the jury selection.
Okay. Mr. Pryor, any thoughts on our current scheduled time frame and whether you think that's adequate?
Judge, I agree. The 8 weeks is, at a minimum, is probably the appropriate amount of time. I think Ms. Blake and Mr. Wood are well aware that, at least in this case, the defense is going to put on a defense. And I have a number of expert witnesses, which is another subject we'll need to discuss. So at least 8 weeks would be appropriate.
Very well. We'll keep the trial schedule as it sits for now then. The next matter I wanted to raise involves the access of cameras in the courtroom in this trial. In this case, I'll note that on September 23rd of last year, an order was entered revoking authorization for live streaming the case that was issued in this case and came about as a result of motions made in the companion case. There was a motion filed by the defense, Mr. Pryor filed on September 29th of last year, requesting that we do allow cameras in the courtroom. And the court issued a follow-up order on October 12th of last year and discussed that if these, at the time the cases were joined and they were later severed, of course, in this order, the court mentions that if the court did order a severance of the cases, I would permit the issue to be revisited and would consider that these separate cases may have separate rationale for allowing or disallowing cameras in the courtroom during trial. So without arguing the motion today, because this potentially raises the right of media intervention into the issue, I would just like to schedule a hearing, and the issue would be the determination of cameras in the courtroom for trial. At last posture, the state opposed it and the defense was in favor of it. Has that status changed on behalf of the state, or do you want to wait until the hearing to more fully discuss that, Ms. Blake?
I think I can indicate at this juncture the state will be maintaining the same position. We can, of course, address it more thoroughly at a hearing on this matter if we end up having one.
Okay. Mr. Pryor, any thoughts on cameras in the courtroom on that issue and scheduling a hearing on that?
Judge, I think it's important that the court set a hearing date on that. Without disclosing a lot of information, I have not returned or responded to the numerous requests from media to pursue a motion like that, and it's quite frankly not my job to represent any of the media people out there that are inundating my email and everything else with requests. But I think at this point, given the fact that this case is going to trial, and I expect the media to probably now jump all over the court's inquiry, we probably better have a hearing and have the matter addressed. Mr. Daybell has not changed his position since I filed this motion, still maintains his feeling about having a public trial, but Judge, I think at the time of the hearing, we'll make a final determination.
Okay, well, let's schedule a hearing then, and I'll want to set enough time that if the parties wish to file any motions in support of or against, what we'll do is it's a hearing to determine whether or not my September 23rd, 2022 order should be amended or altered or left in place. And I'll consider argument on that. So I would think Council, would it be reasonable to look at a December setting for that motion?
Judge, I think that's probably a good idea. Quite frankly, based on the amount of attention I seem to draw on this issue, I can't speak for what the state's getting requests for, but I expect, unfortunately, that a number of media outlets and other folks are going to jump all over this thing, and I think it's going to take some time to properly address it.
All right, I'm just reviewing my calendar. I'm really pretty booked up in December, but I can move things around. I have a little concern. Sorry to sit here and get through my calendar. I've got a couple of trials that I think might be happening with Fremont County on the week of the 11th. What about Thursday, December 7th?
Judge, I have a matter on that day that I have to attend to. I apologize, but other than the week of the 4th through the 8th and the 20th, I'm available at any time. Judge, may I interject?
Yes.
Whether the court decides to have cameras or not is not going to change the tempo of how I prepare. I can't speak for the state. So if the issue was even addressed in January, quite frankly, it would just be the media would have to scramble, and that doesn't necessarily hurt my feelings. So if the court wants to push it to January to make a decision, I wouldn't have a problem. I can't speak for this, whether that's acceptable to the state or not, but I'm comfortable going into January on this issue if we need to.
All right. The alternative I'm looking at is maybe move that up a little bit to November 29th.
I'm available on the 29th, Judge.
I would likely be holding this as an in-person hearing as well, Mr. Pryor, just so you know.
Okay, thank you.
Ms. Blake, would that date work for the state?
That date will work fine for the state, Your Honor.
Okay. Let's set that then for Wednesday, November 29th. We'll set that at 9:30 a.m. in the Fremont County Courthouse.